Your Excellency, the President of the Republic of Uganda, to the Judiciary headquarters. I thank you, Your Excellency, for grace this occasion that is important to the Judiciary. I welcome all our visitors on this commemoration day in honor of the late Benedicto Kajimu Kiwanuka. I particularly and especially welcome Honorable Justice Professor Kote Emmanuel Ni Ashe, a Justice of the Supreme Court of the Republic of Ghana, who is representing the Chief Justice of Ghana. The late Benedicto Kiwanuka was the first Ugandan to be appointed Chief Justice. On 21st September 1972, he was violently kidnapped from his chambers at this High Court building. He is believed to have been murdered by the government of Idi Amin. The late Benedicto Kiwanuka was committed to strengthening the rule of law. He believed in human rights observance. His defense of human freedoms and liberties need no emphasis. The legacy of the late Benedicto Kiwanuka, particularly as a judge and Chief Justice, has been celebrated on this occasion 4 times before now. As Judiciary, we decided to annually recognize and celebrate his late life and his achievements, to remind ourselves and others of his contribution to the advancement of the rule of law in Uganda. Our theme today is Benedicto Kiwanuka, Reflections on the Independence of the Judiciary in Modern Times. This theme should help us consider our past, appreciate the present, and prepare for the future in regard to guarding against human rights violations and promotion of the rule of law. The rule of law and human rights observance are inseparable from independence of the judiciary. An independent judiciary benefits all of us. We require strong and independent judiciary and judicial institutions to foster and enforce the law. An independent judiciary in modern times is essential if we are to achieve the purpose of the new judiciary ushered in by the enactment of the Administration of Judiciary Act 2020. We recognize and appreciate all those who stood for and they cherish the values of an independent judiciary. As an independent judiciary, we stand accountable to the law. We shall always promote and protect the principles of the supremacy of the Constitution, fair and equal treatment of all people. In the performance of our judicial duties, we contribute to the national effort of transforming Uganda by ensuring that all citizens enjoy their rights as they conduct their affairs in accordance with the law. This celebration of life and achievements of Benedicto Kiwanuka calls upon us and on each of us to reflect on what we have done and what we need and can do in the quest for a stronger and independent judiciary and the delivery of justice to the people in a fair, speedy, and impartial manner as commanded by Article 28, Clause 1 of the Constitution. In the performance of its duties and in offering the judicial service to the population, the judiciary cannot successfully operate in isolation from other organs of state.
On behalf of the members of the Uganda Law Society and the East Africa Law Society, which I also head, I take this opportunity to wish you a belated happy 78th birthday. May the good Lord continue to bless you abundantly. Your Excellency, today marks the eve of 50 years since the immortal Benedicto Kiwanuka was last seen in public. Today, we do not mourn him, but celebrate his life. A life that was distinguished in his works, a life that stood for truth and justice, and a life that has continued to impact generations of lawyers and the public. He is acknowledged as a statesman who selflessly promoted democracy and justice in Uganda. Your Excellency, today is also significant because the new Minister of Justice and Constitutional Affairs, the Honorable Norbert Mao, whom I am fortunate to call an old boy, having gone to the oldest school in this country, Namiryango College, is the leader of the Democratic Party today, which party Ben Kiwanuka founded. It is a day of historical proportion, Your Excellency, and allow me on behalf of the members of the Uganda Law Society and the East Africa Law Society, congratulate Honorable Norbert Mao on his appointment as the Minister of Justice and Constitutional Affairs. Today's theme urges us to reflect on the independence of the judiciary in modern times. Judicial independence, Your Excellency, is fundamental to democracy. Addressing the Cape Law Society, the late former Chief Justice of the Republic of South Africa, Arthur Charlson, had this to say: judicial independence is a requirement demanded by the Constitution, not in the personal interest of the judiciary, but in the public interest. For without protection, judges may not be or be seen before the public to be able to perform their duties without fear or favor. The principle of judicial independence is very extensive and complex, but there is a common thread that runs through the various definitions that exist at two levels. First, at an individual level, the ability of a judge to impartially and independently apply his or her mind to a matter without undue influence. And secondly, at an institutional level, which is the ability of the judiciary to control the administration and appointment of court staff. To do this, Your Excellency, the judge must have security of tenure and financial security in order to guard against bribery and related interference and corrupt conduct, and the judiciary must manage its own administrative functions and activities. The pertinent question, therefore, today, from where we stand as a bar, is whether there exists sufficient legislative mechanism to guarantee the independence of the judiciary, what progress has been made to actualize this legislative mechanism, and what threats we see as a bar on the independence of the judiciary. Your Excellency, there has been significant progress made under your leadership towards ensuring the independence of the judiciary. We applaud you for the effort made this far, and we shall highlight some of them. First is the enactment of the Administration of the Judiciary Act 2020. Through this, the judiciary has been able to have increased funding to Uganda shilling 376 billion for financial year 2021-2022. The Judiciary Council has also been inaugurated as a new oversight organ that was established to advise the Chief Justice on the administration of justice and the courts. Alternative dispute resolution interventions like plea bargaining, small claims procedure, and mediations have been promoted. And we now have an expanded structure of the judicial officers and improved remuneration. As the Uganda Law Society, Your Excellency, we have also advocated for the independence of the judiciary as a key tenet for a democratic and rule of law culture. We filed a petition in Uganda Law Society versus Attorney General Constitutional Petition number 52 of 2018, where we successfully argued that the interpretation and scope of judicial independence as laid out under our Constitution included financial autonomy. Allow me, Your Excellency, say thanks to Senior Counsel Francis Jimara, Counsel Wandera Ogalo, those who represented us in this petition. We love to acknowledge our members who push for independence of the judiciary. Your Excellency, the court noted that judicial independence was an integral component of any progressive democracy and observed that judicial independence involved both individual and institutional relationships, and the individual independence of a judge in such matters as security of tenure and institutional independence of the court was also reflected in its institution or administrative relationships to the executive and legislative branches of government. Your Excellency, despite the progress that has been made in terms of fighting for the independence of the judiciary, there are a number of threats which, in our view, need to be addressed as we progressively realize the independence of the judiciary. We do understand that it is not a destination, that it is a journey. The first, Your Excellency, is respect for court orders. Your Excellency, courts in Uganda are clothed with constitutional powers to dispense justice to all persons. Justice is delivered and communicated through court orders, which must be obeyed by all persons, institutions, and authorities in the land at all times. However, Your Excellency, some government institutions treat court orders as mere white papers with blank ink. They are accorded no respect and in some cases no attention at all. Security organs like the police, intelligence agencies, and departments like State House Anti-Corruption Unit, Health Monitoring Unit, among others, must listen to the voice of the law and respect them to the dot. In some cases, a court of law will issue orders maintaining the status quo only for police to go and alter it. Respect of court orders is a cardinal tenet of rule of law, constitutionalism, and judicial independence. And as a bar, we therefore ask for your support, Your Excellency, in ensuring that these organs respect the courts, because it is only when they respect court orders that the independence of the judiciary is realized. Your Excellency, there is also a perception that some judges do not act independently and their decisions are influenced from powers above. This perception, Your Excellency, is fueled by uninformed political statements by politicians, and these need to be comprehensively and properly addressed. Examples include statements to the effect that cadre judges will be appointed to the judiciary, statements alleging that certain judges have been bribed, and so forth, erode public confidence in the judiciary, especially when made by politicians. We believe that anyone aggrieved by judicial decision must appeal that decision using the appellant process, and any disciplinary issues against judicial officers must be raised to the Judicial Service Commission. This perception, Your Excellency, is also fueled by certain judgments, especially relating to the protection of human rights and freedoms. As the court observed in Uganda Law Society versus Attorney General, the independence of judges and courts is not
and we thank the judiciary for persisting in honoring a distinguished man. I do not want to prolong the waiting before we listen to the reflections of our guest speaker, because I believe that no amount of eloquence or even grandiloquence can express the meaning of Benedicto Kiwanuka's life and death. We reflect on how he lived, but we reflect more on how he died, because it says a lot about governance and human rights in our country. I am Minister of Justice and Constitutional Affairs, but I also lead the Democratic Party, the party that Benedicto Kiwanuka took to power when he became the first Prime Minister of Uganda between 1961 and 1962. He was a devout Catholic. He never missed Mass. He had Holy Communion every day. He was not a Sunday morning Christian like some of us. He was far-sighted as a politician and put Uganda first. He served ideals, not just his ambition. He was a loving husband, a loving father. He was a very loyal friend. One of his best friends was the late King Edward Mutesa II, who disagreed with him fundamentally on some political issues. But despite that, when King Edward Mutesa II was in trouble and was exiled, Benedicto Kiwanuka put aside political differences and fought for his return using all the resources at his disposal. Your Excellency and my Lord the Chief Justice, all over the world, governments are grappling with the issue of democratic governance, security, and economic transformation. I want to submit that an independent judiciary is critical in promoting democracy, peace, and economic development. We congratulate the judiciary for the strides made. My Lord, I overheard you promising to the President that in December this building will be complete, because he was saying you are presiding over a building which is roofless, and you told him that if he comes back in December, he will be honored to open the doors to that building. Benedicto Kiwanuka would have been 100 years old this year had he lived, having been born on 8th of May 1922. Today we are celebrating the golden jubilee of his death, which we call a martyrdom. Indeed, agitators and campaigners in the Catholic Church are already making a move to persuade His Holiness the Pope to consider him for canonization alongside the revered Julius Nyerere, another devout Catholic leader and a hero of Africa. Today we are gathered to celebrate Benedicto Kiwanuka's legacy of sacrifice and struggle. These are two things that are familiar to you, Mr. President: sacrifice and struggle. Everything comes at a price. Sometimes you don't get everything you're paid for, but there's nothing you get without paying for it. Today, as we reflect, we ask ourselves, what is the rule of law? There are times when people think the law is an inconvenience. As a student, we read a book called A Man for All Seasons, whose main character is Sir Thomas More, who has been declared the patron saint of politicians. In one of the passages, one of the strongest people in the state, Mr. William Roper, was arguing with Thomas More about the limits of the law and how once in a while you must put the law aside to achieve objectives. So Mr. William Roper asks Sir Thomas More, so now, Mr. More, you give the devil the benefit of law? You know, sometimes we think bad people are not entitled to due process or the benefits of even a fair trial. Sir Thomas More answers, yes, and what would you do? Cut a great road through the law to run after the devil? And William Roper says, yes, I would cut down every law in England to do just that. And Sir Thomas More throws a punch Oh, and when the last law was down and the devil turned around on you, where would you hide, robber? The laws all being flat? This country is planted thick with laws from coast to coast. Man's laws, not God's. And if you cut them down, and you are just the man to
telling you about him. But when I was asked to reflect on his life and the independence of the judiciary, I did some research on him, and I share what I found with you. Exactly 50 years ago, lovers of peace in Uganda and champions of human rights the world over were hit by a tragedy of monumental proportions when the iconic Chief Justice Benedict Kiwanuka was abducted from his chambers at the High Court in Kampala and killed in an unprecedented savagery. A lot of theories swirl around that dastardly act. An official account has it that the late Chief Justice was, quote, arrested by 3 unknown persons armed with pistols, never to be seen again. The Amin government said its investigation showed that the suspects were not members of the security forces. Other reports, however, indicate that Chief Justice Kiwanuka was abducted with full official complicity and shot dead by then military strongman Idi Amin. His head was then chopped off with a dagger, after which the body was dipped in acid solution before burial to kill any evidence or identification in the future. 2 things they say entertain no rivalry: love and power. We are told that Idi Amin perceived his then absolute power to be under the threat owing to the dazzling performance, magnetic personality, and growing popularity of the very man he released from detention and appointed Chief Justice. The more Chief Justice Kiwanuka's fame spread and even dominated cabinet meetings, the more Idi Amin's jealousy was nourished and his anger inflamed. That act of insensible insanity to eliminate the former Chief Justice was finally triggered by his ruling to the effect that soldiers, even on the orders of the all-powerful Idi Amin, had no power to arrest and detain without warrant the British businessman Daniel Stewart, who was consequently released. Unsurprisingly, the Chief Justice had to taste the red-hot fury of Idi Amin in a phone call for opposing his brand of judicial interference and authoritarian intimidation of the most naked kind. In the face of all of this, Justice Kiwanuka was unafraid and unintimidated. Rather, he was as courageous as ever to discharge his duties. Perhaps Justice Kiwanuka drew inspiration from the American civil rights legend Martin Luther King, who postulates, and I quote, "Courage faces fear and thereby masters it. Cowardice represses fear and is thereby mastered by it. Courageous men never lose the zest for living, even though their situation is restless. Cowardly men, overwhelmed by the uncertainties of life, lose the will to live." Unquote. The wife of the late Chief Justice, Mrs. Maxensia Kiwanuka, was spot on in branding her husband as, quote, a kind of Spartan when it came to anybody trying to challenge or deflect him from what he considered to be a moral duty. He would rather die for a noble cause in this wicked world, unquote. Indeed, Chief Justice Kiwanuka's contribution to the moral ecology of Uganda had no parallel, and his inner resolution no precedence. He gave up ownership of himself to serve his nation with absolute distinction, dispense justice with impeccable fairness, and defend the truth and with unwavering commitment. The example Chief Justice Kiwanuka set will continue to ripple in jurisdictions upon jurisdictions and resonate among generations upon generations. My Lord the Chief Justice, Your Excellency, permit me to digress a bit with a reference to Martyrs' Day in Ghana, which is a commemoration of a murderous attack and brutal attack on the judiciary of Ghana. On the 30th of June, 2022, that is earlier this year, Ghana commemorated the 40th anniversary of the abduction and killing of 3 justices of the High Court, Justices Frederick Okusa-Akodie, Cecilia Krantiado, and Kweju Aji Ajepong. Unlike the Ugandan episode, 4 people, including a former civilian member of the then military junta in Ghana, were found guilty by a military tribunal and sentenced to death by firing squad. Although the government's response to that crime was swift and strong, it was not enough to answer all the lingering questions and erase all the widespread suspicion of official complicity in the murders. Consequently, they remain a stain on the conscience of those military rulers in particular and the nation in general. Having spent some time on an important aspect of judicial independence, a bold and fearless judge and judiciary, and fidelity to the rule of law, using the example of Chief Justice Benedicto Kiwanuka, I now turn to more institutional issues relating to the independence of the judiciary. An important component of the rule of law is an independent judiciary. The independence of the judiciary is guaranteed by the Constitution of Ghana and many other constitutions. The judiciary should be an independent and separate arm of government headed by the Chief Justice, who is responsible for the administration of the judiciary. Judicial power is vested in the judiciary, and neither the President nor Parliament shall be given final judicial power. The Constitution of Ghana also provides that neither the President nor Parliament nor any other person shall interfere with judges in the exercise of their judicial power. This requires that the judiciary is objective, fair, and impartial in the administration of justice. To achieve this, it is thought that the processes for the appointment to and promotion in the judiciary must be merit-based and free from extraneous considerations. It is also required that once appointed, judges must have security of tenure and shall not be removed or dismissed except upon stated grounds and after a quasi-judicial process. Another requirement of judicial independence is financial autonomy. Lastly, independence of the judiciary requires that the judiciary is separate from the executive and legislative branches and that it is not influenced by any person in the performance of its judicial functions. It must be noted, however, that this does not mean that the judiciary does not interface with or come into contact with any other institution. challenges to judicial independence using the Constitution of Ghana as the backdrop. As typical of every human system, the independence of the judiciary is fraught with challenges. Therefore, for example, even though the 1992 Constitution of Ghana contains provisions that guarantee the independence of the judiciary, the same Constitution has provisions which pose challenges to judicial independence. These challenges are numerous and are presented on all fronts. They include judicial autonomy, independence in respect of the appointment of judges, security of judges, and the removal of judges. Appointment of judges. In some Commonwealth countries, including Ghana, the democratically elected branches play significant roles in the appointment of judges of the higher judiciary. In Ghana, the Chief Justice is appointed by the President in consultation with the Council of State and with the approval of Parliament. It is evidently clear that the democratically elected President and Parliament play a crucial role in the appointment of the Chief Justice. Does this participation of the executive and the legislative branches in the appointment of the Chief Justice pose a challenge to the independence of the judiciary? My answer would be not necessarily so. It depends on the integrity of the process, and as Chief Justice Kiwanuka demonstrated, the strength and character and the integrity of the holder of the office. Justices of the Supreme Court of Ghana are appointed by the President, acting on the advice of the Judicial Council, given in consultation with the Council of State and with the approval of Parliament, a rather elaborate formula. Justices of the Supreme Court have security of tenure until they reach the mandatory retiring age of 70.
The Honorable Attorney General, the Honorable Minister of State for Defense, let me observe the protocol which the Chief Registrar earlier read in the interest of time. Your Excellency, today we have two awardees of the Benedicto Kiwanuka Award. Let me begin with the first awardee, that is Honorable Justice Dr. Yorokam Bamwine. Dr. Yorokam Bamwine started out as a grade 1 magistrate in 1983 before rising through the ranks to become principal judge in the year 2010, a third position in Uganda's judicial hierarchy after the Chief Justice and Deputy Chief Justice. Dr. Bamwine holds a Bachelor of Laws degree of Makerere University in Uganda, a diploma in legal practice of Law Development Center, Uganda, a Master of Laws degree of the University of Sydney, New South Wales, Australia, which he obtained in 1984/86, and an honorary doctorate of philosophy in humanities of United Graduate College and Seminary International, USA, which he received in December 2013. As an administrator in the judiciary, Justice Bamwine had passion for access to justice for the poor and other vulnerable people in society, such as the widows, children, and orphans. He also had a keen interest in judicial reforms that enhance performance and improve the public image of the judiciary, especially the alternative dispute resolution ideologies. Dr. Bamwine will forever be remembered by the judiciary family for championing mediation, pre-bargaining, and enactment of the sentencing guidelines for courts of judicature. He traversed the country preaching the gospel of mediation and pre-bargaining, yielding outstanding results in delivering quick and acceptable justice, for which we credit him. Honorable Justice Bamwine spoke out on his vision for judiciary in his book titled Honorable Justice Dr. Yorokamba Bamwine, Spurred to Prominence by God's Grace, and is published by SISI African Publishers in 2021. And I quote, "During my tenure as PJ, I was passionate about reforms in the judiciary. For instance, I was instrumental in advocating for alternative dispute resolution. I believed, and I still do, even in my retirement, that though courts of law exist to resolve disputes, a dispute resolved by the parties themselves with the assistance of a neutral person acting as a mediator gives more happiness and lasting peace to the parties than a judgment of a court obtained after years of bitter conflict."
When I look over my life and the sort of recognition the Judiciary of Uganda has bestowed upon me today, I cannot help but praise God for His goodness. I'm extremely honored to be receiving such an important award in recognition of the service I rendered to Mother Uganda as I walked my journey, my judicial journey. It is no doubt that I faced enormous challenges on my way to becoming number 3 in the judicial administration hierarchy. However, each one of those challenges always strengthened me to work on. I've articulated those challenges in my biography, which was mentioned here earlier on, spurred to prominence by God's grace. I will be launching it in December and inviting all of you here. Achieving this milestone would not have been possible without the inspiration of my predecessors. Honorable Justice Ndabova, rest in peace, and Honorable Justice Ogola. It wouldn't also have been possible without the inspiration of my colleagues on the bench, high and low, the advocates, the friends, my children, and of course my dear wife. So I thank them all. Thank you. When joining the bench, we take an oath to exercise the judicial functions vested in us and to do right to all manner of people in accordance with the Constitution of the Republic of Uganda. Our primary duty is to act as conduits of justice. Chief Justice Kiwanuka, the man on whose occasion I've been honored, embodied this principle. He was killed in pursuit of dispensing justice and the rule of law. Now, truth be told, his death has motivated most of us to stand firm amidst work-related challenges. So I, in a way, dedicate this award to him. He was killed at a time when I was still at high school, little known Kitunga High School, later renamed Montreal High School. We had the story, and since then, we've not stopped respecting the reason for which he was murdered. I sincerely do not know how best to express my gratitude for this great honor. Yes, I served with all my heart, and my colleagues here know it. Yes, I gave my all in shaping judicial reforms in this country through spearheading innovative approaches to sentencing and plea bargaining in criminal matters. In fact, at one stage, I was nicknamed plea bargaining. I also participated in innovative approaches in mediation and we spearheaded various reforms to civil justice. However, throughout my journey, I had no idea that my service to humanity would attract such recognition. So to me, I say, God be the glory. To you, my colleagues still in active service, we still labor hard to eliminate backlog and workload. I know we are oftentimes criticized for not trying hard enough to fight delays. However, as C.S. Lewis once observed, and I quote, "It's not the load that breaks you down, it's the way you carry it." We've had situations in this country where people starving to death, where people are starving to death due to famine. There is food to deliver to them, but the tender winning party cannot do much on account of interim, temporary, and permanent injunctions, all in one case. The wheel of justice is clogged by such applications as those waiting for the food die of starvation. So what am I saying here? It is that the judiciary needs the wisdom of King Solomon in our day-to-day administration of justice in order to make justice accessible to those yearning for it. We have to keep on the lookout for the innovative solutions alongside administering justice as it is. There is a lot more to be researched on and implemented in order to make administration of justice accessible. I'm greatly honored to know that my contribution to the lives of fellow countrymen and women was appreciated, and more so when I'm still alive. Thank you so much. This feeling will itself energize me for many more years to come and hopefully inspire others. Thank you, Your Excellency, the President, for being one of those who have shaped my destiny through the various appointments in the course of my service. Thank you, Lord Chief Justice Winyidolo, and your able team for appreciating me. I may not promise to get better at my work so that you can see me here for more such awards, but certainly God will bless you all for putting a smile on an old man's face. God bless you.
You made unfailing engagement with the Judiciary of Uganda. You have religiously attended our functions, not just the Benedicto Kiwanuka function, our judges' annual conference, our new law year, and I know you've written to me promising to attend the incoming meetings of women judges which will be hosted by Uganda. Your Excellency, I see this as testimony of your appreciation of the place the judiciary of Uganda holds in the scheme of things in this country. So much has been said, so much has been written about Benedicto Kiwanuka. I don't think I'll do justice. It would be like a broken record. The people of the younger generation do not know what a broken record means. But those of us who dance to the jukebox, we know how irritating a broken record can be. It repeats the same thing until you lift the needle and put it elsewhere. So let me just say in about a sentence or so, Benedicto Kiwanuka was a man of indomitable willpower. He was a principled man, and many times we tend to forget, I think Honorable Mao, who sits in the seat where Benedicto Kiwanuka once sat as president of the Democratic Party, mentioned. His being principled was not as a judicial officer only. It was not accidental. It was not determined by the occasion or the nature of the employment as a judicial officer, protected by the Constitution as an independent person. Even as a young politician, the fellows who gave us independence, he was principled enough to stand up and say the Democratic Party is a national party. And what the Uganda People's Congress did, he could have done it. I don't know what our history would have been today. But he was principled enough to say, no, Uganda is a nation, I stand for a national party. And as the Honorable Mao said, it angered Mengo, although apparently he made peace with Mengo later. So by nature, he was a principled person. He was a person who was prepared to lose all to achieve what was right in the eye of God and in the eye of man. This year, we invited the Chief Justice of Ghana to come and deliver the keynote address, and he graciously, although he's indisposed, he graciously sent the most senior member of the Supreme Court of Ghana. Your Excellency, Ghana does not have a Deputy Chief Justice. So in the absence of the Chief Justice, the most senior member of the highest court, the Supreme Court, acts in the place of the Chief Justice. So we've been sent here, the person next to the Chief Justice of Ghana, to present the address which he would otherwise have done himself. Honorable Justice Professor Emmanuel Nii Asikoti, you're most welcome to travel from the west coast of Africa to the east coast of Africa. I think it is an experience. As you know, I was in your country 2 weeks ago, and that was the first time I was in West Africa. And for some very intriguing reason, the Ghanaian people are like Ugandans. In many ways, what I noticed was what you would notice in Kampala, you would notice in Gulu or in Mbarara. So I'm sure you feel you're at home. Please enjoy your stay here. We share a common history and experience. You talked about it, the martyrdom of judicial officers in Ghana, and the one you've come here to address us on. Benedicto Kiwanuka was the first Ugandan to serve as Chief Justice. He was the second African to serve as Chief Justice in Uganda here, after Udo Udoma from Eastern Nigeria. What Benedicto Kiwanuka has been described to have been was his trademark sense of righteousness and commitment to the straight ways of justice. And it is this that put him at loggerheads with President Idi Amin. Whatever account that have been given by eyewitnesses, by the government of the day, The circumstantial evidence is compelling. It is unmistakable that Idi Amin took the life of Chief Justice Benedicto Kiwanuka. The person who took oath to protect the life and properties of Ugandans took the life of one of the persons he took oath to protect. In law, Your Excellency, we say circumstantial must be so good as not to be mistaken or controverted. But we also have a saying that many times circumstantial evidence can prove a case with mathematical precision. And the case of Chief Justice Kiwanuka is one of those proof by circumstantial evidence as to who were responsible for his demise. He was martyred for his unflinching advocacy against arbitrary arrest, extrajudicial killings, torture, and the utter disregard for the rule of law that painfully characterized the infamous government of Idi Amin in the 1970s. As the judiciary family, we acknowledge the noble role Kiwanuka played in the promotion of the observance of the rule of law and respect for human rights, for which he paid the ultimate price. We are called upon to mirror the life of the indomitable Benedicto Kiwanuka and ask ourselves what we have so far done and what else we can do for our people. Our reminiscent theme this year is Benedicto Kiwanuka, Reflections on the Independence of the Judiciary in Modern Times. The martyrdom of Ben Kiwanuka was a consequence of his determination to assert the judicial independence in the face of the chief executive, who had no regard whatsoever for the rule of law. Now, in 1985, the United Nations outlined basic principles on independence of the judiciary. This includes guarantee by the state, and this should be enshrined in the Constitution, the independence of the judiciary, and the duty of all governmental institutions, departments, and persons to respect and observe the independence of the judiciary. Second, the duty of the judiciary to determine matters with impartiality, basing on the facts before them and the law. And there must be no restrictions, improper influences, inducements, pressures, threats or interference, direct or indirect, from any quarter or for any reason. Then the judiciary is under duty to exercise jurisdiction over all issues of a judicial nature and shall have exclusive authority to decide whether an issue submitted for its decision is within its competence as defined by law. 4, there shall not be any inappropriate or unwarranted interferences with the judicial process. 5, everyone shall have the right to be tried by ordinary courts or tribunals using established legal procedures. The principle of the independence of the judiciary entitles and requires the judiciary to ensure that judicial proceedings are conducted fairly and that the rights of the parties are respected. It is the duty of each member state, and Your Excellency, Uganda is one such state, to provide adequate resources to enable the judiciary to properly perform its functions. These principles enunciated by the United Nations are clear. Let me add, they are actually embodied in our Constitution of 1995, either using the same words or using different words. The principles are clearly enshrined in our Constitution with regard to the Ugandan judiciary. Now, judicial independence will also be guaranteed through, among other things, appointing suitable and qualified persons into judicial positions, ensuring judicial officers enjoy security of tenure, willingness to respect and enforce court decisions regardless of who is affected by the decisions, and making the courts accessible to the common man seeking for justice. That is the issue of access to justice, which is the main force propelling our agenda under my administration. As we reflect on the independence of the Ugandan judiciary today, I must state that this theme resonates with the theme of the just concluded Commonwealth Magistrates and Judges Conference in Accra, Ghana, which was the issue of access to justice in the modern times. I was privileged to attend and to present a paper on the role Uganda is playing in this regard. One of the highlights was the need to strengthen the financial and administrative independence of our judiciaries. Your Excellency, allow me to thank you and the Parliament of Uganda. Once again, I've done it before, but I will not tire of saying it owing to its importance. To thank you and the Parliament of Uganda for the administration of the Judiciary Act 2020. This was the game changer with regard to the issues we speak about, independence of the judiciary and so on and so forth. This has enabled the judiciary of Uganda to make tremendous gain. But allow me again to thank you at a personal level, owing to your, as I said, unprecedented engagement, discernible engagement. We say overt. You had engaged with the judiciary, but that was covert. The ordinary eye would not see. But now your engagement with the judiciary is overt.
We are the ones who removed the killers of Ben Kiwanuka. That should be clear. Because those who are killing these people who were there, they were the colonial soldiers, Idi Amin and the group, and who removed them? The freedom fighters, the NRM. That's number one. So because we removed these killers, that's how we are able to have all this, what is happening, to remember, to do this, to discuss on how to move forward. Number two, the freedom fighters brought democracy. You remember, between 1962 and 1980, there were no elections in Uganda. That's 18 years. No election, not even bad elections. In 1980, we had elections. There were bad elections, but there were some attempted elections. So, number one, we removed the killers by force, not just by talk. Number two, brought democracy. Number three, dismantled the sectarian system which had paralyzed Uganda and Africa for all those centuries, because we had sectarianism before the Europeans came. The tribes, these tribal chiefs, with their egocentrism. You find a little king says that he's a lion. A lion of whom are you eating? Why don't you eat the imperialists who are disturbing us? You are only eating local people. So we have to dismantle that sectarianism, because the CJ touched on it. I will talk about it later. If it was not for sectarianism, Uganda would never have had the problems we had. They were caused by the sectarian actors. So that's number three. dismantle or at least challenge the sectarianism of religion and tribes. Number 4, repair the economy. See, we are talking of money. Money from where? You cannot have money unless the economy is repaired. You know what was happening here in the economy. You know, there was no money. No money for the government. Why? Because all the enterprises had closed down. They had collapsed. So we had to repair the economy to bring back to allow the enterprises to come back so that they can do business, and then they create jobs and so on, produce goods and services, but also pay taxes so that the government has got money. So it's good that today this man, my manager, Dr. Mona, my PPS, did not rush me. That's why I was able to sit here for a long time and listen carefully. So number 4, repair the economy. And that's how we are able to talk of more budget, more this, because the economy has been somehow repaired and it has expanded in spite of the bigger population. Because remember, the population of Uganda was 14 million in 1986. It is now 43 million. So in spite of the population growing so much, but the economy is much bigger now than it was in 1986. Then number 5, ensure peace. Ensure that there is no war in Uganda, that there are people can be able to build their lives, but also deal with these other issues, organizational issues, judiciary, politics, what have you, church. Everybody is able to do something now. And then number 6, support financially, because this is the aspect you are talking about now. Support financially the government structures, army, judiciary, all this. So this is the context I would like you to remember. Now, this brings me to something we have not really done, because we have not had time. We talk about it, but in a passing way. To engage you, the lawyers who are trained in the Western system, to give you our viewpoint. I sometimes mention it, but I never concentrate on it. So when you talk, so this would be number 7 now. I'm now going to pay more attention to it, because I have never really had time to concentrate on it. When you call me, I mention it and I go away. Now this is the independence of the judiciary. Independence from whom? You cannot be independent of the Ugandan people. So I would want some amendment to this idea. Maybe you could talk of independence within a convergence of principles of justice. Because the problem I see, I talk about sometimes, but then we don't concentrate on it. The head of the new lawyer president was talking of the refusal of some groups to implement court decisions. This is very serious. It is not, I would want us to really get time, not now. This is just an occasion of celebrating, of commemorating, but we should get time and discussing it deeply. Part of the problem why they don't implement the court decision is actually they don't agree there is lack of convergence on what is justice between, in some of the cases, between the courts and sometimes the population and even the political side. Like for instance, we have got a problem of land issues, especially in Uganda. And you know that problem of the Milo land was created by the British here in Uganda. So you have got 5,000 people in a parish, and the magistrate says, no, all of you must vacate, because he has, we don't know what he has agreed with the landlord. No, the RD says, no, they can't leave. This is what you are talking about. So what is the problem here? Who is right and who is wrong? That's why, really, I went back to my old political party, the DP. Unfortunately, I found there a comrade, a young comrade called Mao. And I said, you, comrade, come and help me with this, because you're a successor of Kiwanuka, but you're also a lawyer. And I heard him talking well, because he was talking of the whole government, What is the position, what is the historical position of the Ugandan reformers? Because we are reformers. We, the freedom fighters, and you, the lawyers. How should we handle the issue of Mairo and the tenants, Bevanja and all these people? How should they be handled? If you come just artificially and you say, oh, court has decided that 5,000 people leave the parish, we say rubbish, they can't go. RDC comes in and says. So it's not such a simple issue. So therefore, because if you say independence, this is really abuse of power. Because you are using that cover of independence to do big injustice to the population, which can cause even very serious security problems. We had the problem of the bail, We had that problem of bail. So therefore, it is correct that the judiciary should be independent, for sure, but it should be independent within a convergent national system. Having agreed on these big issues, how do we handle the issue of the historical distortions of, for instance, land in some of these areas? How about murder? Because I have told you many times when I come here, the tribal views about murder. For the tribes, it is an eye for an eye, a tooth for a tooth. If you don't do that, you are going to cause problems to. That's how you get the skepticism of the population. So therefore, on this one, I would want, of course you can say, it is in your area, you are the legislator, you are the president, you have got a political party, the political party has been winning elections all this time, you legislate the way you want us to do things, and I totally agree. So there I plead, I would not say plead guilty for neglect of duty, but I will plead with mitigation, that I was busy with the other 6, busy with the killers busy with the repair of the economy, busy and so on and so forth. But now that we keep talking about this, I'm really going to pay more attention to from the judicial side, from the legislative side. From the legislative side, and Chairman Mao here will help me to concentrate the new Uganda. What should be the doctrine of accountability on this one, that one, that one, that one. But of course, there is still some resistance also from your side, because this issue of bail, for instance, those who were in the CA, including the Chief Justice, he was in the CA, in the Constituent Assembly, they provided that a judge may give bail. They didn't say you must, but some of them just give even when you can see that it's not wise. It's very dangerous, very provocative. That's how now you get mob justice, where the people take the law in their own hands and they kill the suspects because they think the judiciary will not punish them. But I think now, I should do my side now to really sit down and say, on this issue, this is our doctrine of justice. For instance, there are big problems which I imagine where the children are mistreating parents in the villages. Because we had our traditional justice in which the parents were sort of dictatorial. But now you have the children using this unclear system, behaving badly and disturbing parents. And that one we need to. It's not. I don't think it is clearly addressed. But I therefore agree that on our side, on the legislative side, we need to come and bring out any issue which we think is crucial to bring satisfaction, and we legislate on it, and we bring it to you in the form of law. Now, coming to Ben Kiwanuka, I'm very glad the CJ talked about it. You cannot talk of Ben Kiwanuka just as a lawyer, because he started off. First of all, Ben Kiwanuka was a soldier. I don't know whether you know that. He was a soldier in the Second World War. That's what I heard. He was in the Second World War as a soldier. When the war ended, he was one of the few Ugandans who went to South Africa, I think, South Africa, or somewhere, Fort Hare or something, and studied law. I don't know whether he studied in Britain or South Africa, but he studied law. And when he came, he got involved in the politics. And as the CJ said, he was very principled for sure, because he stood against the tribal chauvinism of Mengo and said, no, we cannot keep on pushing tribal agendas. We must have a national position. And although DP itself was still, because I was a member of that DP myself, so actually Kiwanuka was my senior colleague, because I was already very active, and I worked with him actually. I met him and we were working together. although DP still had its own sectarian side, being mainly a Catholic party, but at least on the national unity, they took a correct position. And we should salute him for that, even before you talk about the legal side. The legal side, I have got some criticism, because these were our colleagues. By that time, I had finished university, and we were engaged already. But on the national issues, he definitely took a correct stand. And if UPC or Bote had not been opportunistic and gone to please Mengo, Uganda would never have had political problems. You would have had a national consensus of telling Mengo, stop that nonsense of sectarianism. And Uganda would never have had all this chaos we had. So this chaos was caused partly by the double-facedness of UPC, saying we shall give Mengo what is impossible, and then later on they found they can't do it, and then they had to use now force, when they could have simply joined with DP and said, no, what you are talking about is not correct. So definitely, there, Kiwanuka made a good stand. Now, when Amin came in, we, the political actors who were there, had a difference. Because I had been in DP myself, although at that time I was working, I had been recruited, I was working in the president's office. When Amin came in, there was a division among the political class. Some of the people like Ben Kiwanuka, some of the DPs like Ben Kiwanuka, and some of the others like the Nabudere, Rugumayo, Wanume Kibedi, who were part of our, because we were also like a leftist group. Although I had been in DP, by this time we had evolved ideologically, and we were like a leftist group, a radical group. So we had differences among us.